Do you know what actually happens, legally, the moment an Australian police officer asks you, "Where are you off to tonight?" Most people assume the honest answer is the safe answer. It isn't dangerous to answer, exactly, but it isn't required either. And almost nobody watching this knows that. The common belief is that a forward-looking question like this one is just conversation. Harmless small talk that has nothing to do with your rights. That's the myth. It's false. And Australia's highest court settled why decades ago for the entire country, not just one state. Picture the moment it happens. Window down, license already in your hand. The officer glances at it, hands it back without a word yet, then looks past you down the road ahead, not behind you. Where are you off to tonight? It sounds different to the backward-looking version of this question. This channel has already covered. It sounds forward-looking, almost harmless. He's not digging into your past. He's just making conversation about where the night's headed. That framing is doing exactly what it's designed to do. Because legally, where are you going and where have you been are the same question wearing two different tenses. By the end of this video, you'll know exactly what the High Court ruling says. The one situation where staying quiet can genuinely cost you later. And the phrase that handles the forward-looking version of this question, the same way this channel has already handled the backward-looking one. Quick word before we get into it. No invented authority on this channel. Just plain English, Australian law, checked against the actual statutes, and case law. Every section sitting in the description below. Here's the ruling this whole video sits on. Petty and Maiden versus the Queen. Decided by the High Court of Australia in 1991. The court held, as a fundamental rule of the common law, that there is no legal obligation on a citizen to answer questions put by police, and that a person's silence in the face of police questioning cannot, on its own, be used as evidence against them. This isn't a state-level ruling that might apply differently across borders. It's the High Court. It sits above every one of the state and territory statutes this channel has ever cited, and it covers questions about your future exactly the same way it covers questions about your past. There's nothing in the reasoning that carves out an exception for tense. New South Wales writes this same protection directly into Section 89 of the Evidence Act, which prevents a court from drawing an unfavorable inference from the fact that you declined to answer police questioning before you were charged with anything. Victoria and Queensland rely on the same common law principle Petty established, since the right to silence is a common law right recognized nationwide, not a state-by-state creation. So why does "Where are you going?" get asked at all, if it carries no more legal weight than the question this channel already covered? Because it does a different job for the officer, even though it carries the same legal answer for you. Where have you been? Builds a timeline backward, toward whatever already happened tonight. Where are you going? Builds one forward toward whether you're likely to keep drinking once you get there, whether the destination matters to an existing bail condition or an apprehended violence order neither of you has mentioned yet, or simply toward whether your answer matches what a second officer is hearing from someone else in the car. The tense changes. The purpose building a voluntary account you didn't have to give doesn't. The mistakes here run parallel to the ones this channel has already named, with one new one that's specific to the forward-looking version. Error 1. Treating a friendly, forward-looking question as automatically less risky than a backward-looking one. Just heading to a mate's feels harmless to say. It's still a voluntary statement, on camera, that ties you to a specific place at a specific time, and if anything about that destination matters later, for reasons that have nothing to do with tonight, you've already put yourself there in your own words. Error 2. Inventing detail to sound more credible. The driver who adds, "Just for a couple of hours, we're watching the game," when a flat, honest non-answer would have done exactly the same legal job, has built a claim that can be checked and contradicted later. Error 3. The one specific to this version of the question. Treating "Where are you going?" as if answering it is somehow required, because it sounds forward-looking and practical, almost like a safety check rather than an interrogation. It isn't a safety check. It carries precisely the same optional status as every other movement question this channel has covered. And petty draws that line at the level of the entire country, not just at a state border. Now, the edge this channel always names, because pretending the right to silence has no limits anywhere, would be dishonest. New South Wales has a provision, the Special Caution, under Section 89A of the Evidence Act, that lets an unfavorable inference be drawn from silence, but only in a narrow, specific circumstance. You must already be under arrest for a serious indictable offense. A special caution must be given in the presence of a legal practitioner, and you must later rely at trial on a fact you failed to mention when specifically asked about it under that caution. That is a world away. From a roadside question about your evening plans, it requires arrest, a lawyer physically present, and a formal caution read out loud, none of which describes a casual, "Where are you off to?" through a car window. Know that the exception exists, so you're not caught off guard by it later, but also know precisely how narrow it is, so you don't talk yourself out of a protection that still fully applies to you tonight. So here's the phrase, built the same way the earlier ones were, because the underlying law hasn't changed, only the tense of the question has. Asterisk, asterisk, here's my license, officer. I'd rather not get into where I'm headed. Asterisk, asterisk, say it again, slower, because the second pass is the one that actually stays with you. Asterisk, asterisk. Here's my license, officer. I'd rather not get into where I'm headed. Asterisk, asterisk. Every word is doing the same job it did before. Here's my license satisfies whatever's genuinely compelled at that. Stop your identity, your license if you're driving, the parts of the exchange no version of this question touches. I'd rather not get into where I'm headed. Declines the voluntary half, cleanly, without turning it into an argument. Petty already told you why that's safe to say. No legal obligation exists to answer, and your silence on it cannot become evidence used against you later. Picture the whole exchange, window down, license out, before he's even asked for it. Where are you off to tonight? You, calm, unhurried. Here's my license, officer. I'd rather not get into where I'm headed. He glances at the license, hands it back. No worries, drive safe, window up. Nothing in that exchange was defiance, and nothing in it was concealment either. You answered every part of the question the law was entitled to, and kept the one part it was never entitled to in the first place. Worth spending a moment on where Petty actually came from, because the facts behind it explain why the High Court reasoned so broadly. The case involved an accused person who, during police questioning before trial, declined to answer certain questions, and later gave an account at trial that differed from what he'd said, or hadn't said, at the time. The Crown argued his earlier silence should count against his credibility. The High Court disagreed, and it disagreed in sweeping terms not narrowly tailored to the facts of that one case, but stated as a general rule of the common law, applying to any citizen questioned by police about any topic, at any stage before charge. That breadth is exactly why this channel can say with confidence that a forward-looking question at a roadside stop falls inside the same rule as a backward-looking one. The court wasn't drawing a map of permitted and forbidden topics. It was stating a principle. Silence in the face of police questioning is not, by itself, something a court can hold against you. A word for whoever's sitting in the passenger seat. Because this question doesn't always stay pointed at the driver. If the officer leans across and asks the passenger the same thing, "And where are you two headed?" the same principle protects them, independently of whatever the driver says. A passenger has no more obligation to narrate the trip's destination than the driver does, and neither person's silence can be treated as suspicious just because the other one also declined. I'd rather not get into that either. Works from the passenger seat exactly the way it works from the driver's, and there's no legal requirement that the two answers match, because neither one was ever owed in the first place. Now, the version of this that doesn't end quietly, because a channel that only shows the easy outcome isn't preparing you for the real one. Same opening. Where are you off to tonight? You answer, calm. Here's my license, officer. I'd rather not get into where I'm headed. Instead of moving on, he presses. It's a simple question, mate. Why so cagey? You don't reach for a justification, and you don't get defensive about the fact that you're allowed to decline. Same words, same level. I understand, officer. I'd still rather not get into where I'm headed. A pause. He checks the license against the system. If nothing outstanding comes back, that's usually where it ends. No worries, on your way. Because a declined question, on its own, was never going to become the reason for anything more. Petty settled that 30 years ago, and nothing about a driver holding the line politely changes it. There's a broader pattern worth naming here, because it's the same pattern that made the earlier videos on this channel necessary in the first place. Officers are trained to keep a conversation moving, and a moving conversation naturally drifts toward whatever's easiest to ask and easiest to answer. Where are you going is easy to ask, and for most people, easy to answer without thinking twice about it. Because it doesn't sound like an interrogation. That ease is exactly why it works as well as it does, and exactly why the fix isn't complicated once you know it. You're not being asked to be cold or unhelpful. You're being asked to notice the one moment in an otherwise ordinary conversation where an easy question is doing a job the law never required you to help it with. A genuine state-by-state note, because the statutes that sit alongside this common law principle aren't worded identically everywhere. Section 89 of the Evidence Act applies in New South Wales specifically, preventing an unfavorable inference being drawn from pre-charge silence in proceedings governed by that act. Victoria and Queensland don't have an identically numbered provision, but rely on the same High Court authority in Petty, which binds every state and territory court in the country, regardless of the Local Evidence Act's exact wording. What changes at each border isn't the underlying right. It's the specific, compelled disclosure triggers layered on top of it. The ones this channel has already covered in earlier videos: identity requirements, license production, breath and drug testing. Those triggers vary by state. The right to decline a movement question, forward or backward looking, does not. One last practical note, separate from anything said in the moment. If a stop ever goes further than a simple exchange, if declining this question becomes the stated reason for anything else that happens, a longer detention, a search, a request to step out, write down what was actually said as soon afterward as you can, in your own words, including the exact question asked and the exact reason given, if any, for what followed. Petty protects you in the moment by making clear your silence isn't evidence of anything. A written record protects you afterward, if the question of what actually happened at that window is ever revisited by someone who wasn't standing there. Now the fork, because sometimes there's a genuine specific reason behind the question, not just habit. If the officer names one a real trigger, tied to a bail condition, an exclusion zone, under an apprehended violence order, or a specific investigation he can point to, that changes what's compellable. The same way it did in every other version of this stop this channel has covered. You don't argue a properly grounded requirement. You comply with what's actually named, and you still decline anything beyond it. What you're protected against isn't a genuine, articulated reason. It's a habitual question asked because it usually works, not because there's anything behind it. It's worth being specific about why a destination, rather than a general direction, can matter in a way a past location sometimes doesn't. If there's an apprehended violence order in place, naming a particular address as off-limits, or a bail condition restricting where someone can go or who they can be near, confirming a destination out loud does something. A vague answer never would. It ties a specific place at a specific time to a specific person in a way that's very hard to walk back later if it turns out that address mattered. None of this means you're doing anything wrong by declining to answer. It means the stakes behind a seemingly casual question aren't always visible from where you're sitting. And the safest assumption is the same one this channel has repeated in every version of this stop. If the compelled half of the exchange doesn't require the answer, there's rarely a good reason to volunteer it, whatever the actual destination happens to be. The trained officer generally has two ways of pushing on a declined answer. And they're the same two this channel has already named in earlier videos, because the training behind them doesn't change much from one question to the next. The first wears sympathy. No worries if it's nothing, but you can understand why I'm asking, right? You don't reach for a justification, and you don't feel obligated to prove there's nothing to hide. Same words, same tone. I understand, officer. I'd rather not get into where I'm headed. The second wears mild pressure. It'll go a lot quicker if you just tell me. It won't, and the phrase doesn't trade with the implied cost. Same sentence again, said with the same evenness as the first time. By the third repetition, in your own head right now, it's something you can reach for automatically. Which is the entire reason this channel says these lines out loud twice in every video, not for the camera, for you. To close it out, where are you going, feels like a different question to, where have you been? But the High Court has already told the entire country it isn't, and that ruling doesn't weaken at any state border. Your identity and your license give them every time. No argument. Your plans for the next 10 minutes are exactly as private as your last 10, and the phrase that protects both directions barely needs to change tense at all. Here's my license. Officer, I'd rather not get into where I'm headed. This is general information, not legal advice. And the narrow exceptions to the right to silence, like the special caution provision, apply in very specific circumstances involving arrest, a legal practitioner, and a formal warning read aloud. And don't cover an ordinary roadside stop. If a stop goes further than a conversation, the video ends and a lawyer begins. Legal aid exists in every state. Share this with the person who's only ever heard the backward-looking version of this and assume the forward-looking one worked differently. Or with the mate who always over-explains his plans to anyone who asks, badge or no badge. Tell me in the comments, has an officer ever asked where you were headed, not where you'd been, and did it feel different to you at the time? Subscribe for the next stop, because next time, it isn't your plans they're asking about, it's the phone in your pocket. That video's coming next.